Good morning. Today is Tuesday, April 10th, 2018. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Mrs. Bohannon, will you please call the roll?
Dennis Bridges.
Here.
Mark Cochran.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford III.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Mrs. Bohannon. First item on the agenda is the adoption of the agenda.
So move. Second.
I have a motion by Clark McKinney and a second by Mr. Duffer. All in favor?
Aye.
We have the minutes from the March 13th, 2018 meeting. I think all of you've got those to review.
Move to approve. Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
Opposed? Next, we have our legal report. Ms. Gino.
Good morning. My name is Ashley Gino. I'll be presenting the legal report this morning. The first four complaints on the report are related, so I'll read the complaint numbers for those and then I'll get into the summary. Complaint number 2018-003611 is an establishment with some disciplinary history. Complaint number 2018-003651 is a funeral director, no disciplinary history. Complaint number 2018-003671 is an embalmer with no disciplinary history. Complaint number 2018-003631 is an unlicensed funeral director, no disciplinary history. Upon routine examination on December 28, 2017, it was discovered that 1. A new owner purchased the respondent establishment on June 8, 2017. However, at the time of the inspection, neither the respondent establishment nor the new owner submitted a change of ownership notification. A. To date, no change of ownership notification has been sent to the Board of Funeral Directors and Embalmers. 2. The funeral director's license was not available for inspection at the establishment. A. The listed funeral director listed as the establishment manager of records responded to the complaint, advising he was incorrectly listed as the manager. He further advised that he had not at any time written, signed, or submitted a written document stating that he was the funeral director, embalmer, or manager for the respondent establishment after the establishment was purchased by the new owner. B. On February 14, 2018, the department received a response from the new funeral director and manager advising he has been serving as the manager and funeral director for the respondent establishment since January 2, 2018. He advised his license is currently available for inspection. 3. The current embalmer's license was not available for inspection at the establishment. A. The new funeral director and manager for the establishment advised the embalmer's license is currently available for inspection. 4. The current license and inspection report of the crematory utilized by the respondent establishment was not available at the time of inspection. A. The new funeral director and manager for the establishment advised the crematory's license is currently available for inspection. 5. The funeral file for the funeral services performed on behalf of one of the decedents was not available during the time of the inspection. A. The new funeral director and manager advise that all records are in a file cabinet in the manager's office and available for inspection. Six, despite not being licensed as a funeral director, the new owner engaged in funeral directing for 3 decedents. Specifically, he signed the Statement of Funeral Goods and Services Selected contract for one of the 3 decedents, and also made funeral arrangements for another one of the 3 decedents while the investigator was conducting the inspection. There was no licensed funeral director present at that time. A. After the new owner purchased the business, the family of one of the 3 decedents came to make funeral arrangements. The family presented the new owner with a prepaid funeral contract. The new owner investigated but could not determine where the money was placed for this contract. The new owner gave a solid oak casket to the family at no charge, purchased a sealer concrete box out of his own money, and provided all services for that decedent at no charge. 7. The signage on the front door of the establishment listed the new owner's name with the caption "Owner," but did not designate that he was neither a Tennessee licensed funeral director nor Tennessee licensed embalmer. The same was true for the new owner's business cards. A. The new funeral director and manager advised his name is being used, shown, or displayed at the funeral establishment. 8. There were several errors and/or omissions in the general price list. A. The majority of errors and/or omissions in the general price list were corrected by the new funeral director and manager. A copy of the new general price list, casket price list, outer burial container price list, and Statement of Funeral Goods and Services Selected contract were provided. 9. There was no reason for embalming listed on the Statement of Funeral Goods and Services Selected contract for one of the 3 decedents. Recommendation. 1. Establishment. Complaint number 2018-003611. Authorization for a formal hearing, authorization of a civil penalty in a total amount of $3,250 to be reduced to $2,500 if respondent provides proof that an application for a change of ownership with all necessary supporting documents has been submitted to the Board of Funeral Directors and Embalmers within 30 days. 4. A. Failing to submit a change of ownership notification to the Board of Funeral Directors and Embalmers. B. Failing to have a funeral director's license available for inspection at the time of the examination. C. Failing to have the embalmer's license available for inspection at the time of the examination. D. Failing to have the crematory's license and inspection report available for inspection at the time of the examination. E. Failing to have the funeral file for funeral services performed on behalf of one of the decedents available for inspection at the time of the examination. F. Aiding and abetting an unlicensed individual to engage in funeral directing. G. Displaying the new owner's name on the front door without indicating he was neither a licensed funeral director nor licensed embalmer, and displaying the new owner's name on business cards without indicating he was neither a licensed funeral director nor licensed embalmer. H. Errors and/or omissions in the GPL. 2. Listed/former funeral director/manager. Complaint number 2018-003651 and complaint number 2018-003671, closed with a letter of warning. 3. New owner. Complaint number 2018-003631, authorization for a formal hearing, authorization of a civil penalty in an amount of $1,000 for unlicensed funeral directing.
Need all of these in one motion, or should they be separate?
That was going to be my question to Ms. Gino.
I think we can have it all in one.
Motion to accept council's recommendation.
I have a motion by Mr. McKinney, a second by Mr. Bridges. All in favor?
Aye.
Opposed?
Complaint number 5, 2017-074231. It's an establishment with some disciplinary history. Complainant alleged 1, unauthorized removal of her father-in-law's remains from a nursing home, and 2, that respondent refused to allow a transfer of the remains to another facility, wanting to be compensated for the services it performed. On the first allegation, respondent indicated the nursing home authorized it to remove the decedent's remains because it was unable to get in touch with any members of the family after the decedent passed. Respondent further stated the nursing home called respondent because respondent's name and phone number were in the paperwork for the decedent when he was admitted into the nursing home. These statements were corroborated by the nursing home. On the second allegation, the respondent stated while it did initially request the family pay for services rendered, removal charge, and embalming, as it believed these services were authorized by the nursing home, neither the family nor complainant were billed for such services. Respondent also indicated it did not refuse to allow the transfer of remains to another facility. On the same day respondent received the remains and decedent passed, respondent transferred the decedent's remains to the requested establishment. The receiving establishment cooperated this. The funeral director/manager for the receiving establishment stated there were no problems with the transfer. Recommendation, close.
Motion to accept.
Second.
I have a motion by Mr. Cochran, a second by Mr. Davis. All in favor?
Aye.
Opposed?
Item number 6, complaint 2018-00386161 against an establishment with some disciplinary history. Upon examination, it was discovered respondent operated and conducted services for 5 decedents while its license was expired, December 1st, 2017 through December 12th, 2017. In response, respondent purported that on or about the middle of November 2017, the location manager spoke with someone during a call to the board who allegedly told him the license renewal had a 30-day grace period. Respondent further purported one of the 5 services performed was a memorial service held on December 2nd, 2017 for a cremation which took place on November 30th, 2017. Recommendation, authorization for a formal hearing, authorization of a civil penalty in an amount of $250.
Motion to accept council's recommendation.
Second.
Motion by Mr. Duffer, a second by Mr. Shackelford. All in favor?
Aye.
Opposed?
Item 7, complaint 2018-007551 against an establishment with some disciplinary history. On February 2nd, 2018, complainant submitted a complaint against respondent alleging he had yet to receive his father's remains/ashes despite receiving the death certificate on February 1st, 2018, and contacting the respondent on 4 occasions in January 2018 regarding the remains. By a letter dated February 20, 2018, respondent responded to complainant/consumer's allegations as follows. 1. On December 12, 2017, decedent's family inquired about making arrangements for the decedent. The family's initial plans were to have a funeral on December 18, 2017. However, on December 18, 2017, the family requested the funeral be moved to December 21, 2017. On December 20, 2017, the family advised they wanted a visitation and cremation instead of a funeral. 2. The family had a first viewing. Before the cremation, however, the respondent was advised decedent's sister would be coming in for a viewing and that a family friend would come in to take pictures. The sister came in for a viewing the week following the first viewing, but the family friend never came. 3. The cremation request was sent to the nursing home on January 2, 2018 and was returned to respondent on January 17, 2018. In between this time, respondent indicates it had to keep pushing the appointment at the crematory because the doctor had not submitted the form for respondent to send to the medical examiner's office to get permission to cremate. 4. Respondent received permission from the medical examiner's office on January 19, 2018. After this, respondent made an appointment with the crematory. The respondent and crematory agreed that due to the icy weather conditions and unsafe condition of the streets, the matter would be taken care of the following week. 5. On February 3, 2018, respondent called complainant to inform him decedent's ashes were ready to pick up. Recommendation, close.
Further questions for Ms. Gino?
Motion to accept council's recommendation.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
Opposed? Next.
Item 8, complaint 2018-009-071 against an establishment with some disciplinary history. Complainant, the decedent's sister, alleges she gave respondent specific instructions of the decedent's wishes that his remains not be viewed by anyone. Despite these instructions, however, respondent allowed the decedent's brother to view his remains. Complainant further alleges that when she spoke with the funeral director about allowing the brother to view the remains, the funeral director told her to pray about it. Respondent admits the funeral director told complainant to pray about it after she expressed concerns over her brother viewing the decedent's remains. Respondent indicates it saw no harm in allowing the brother to view the remains and that the brother told the respondent that the complainant had given him permission to view the remains. Tennessee Code Annotated Section 62-5703 dictates the order in which right to control disposition of remains vests. Based upon the information gathered during our investigation of the complaint, it does not appear the complainant had any greater right to control the disposition of the decedent's remains than the brother had. Recommendation: authorization for a formal hearing, authorization of a civil penalty in an amount of $250 for unprofessional conduct for the manner in which the funeral director treated complainant.
What are we saying is the unprofessional conduct?
Telling the complainant to pray about it when she expressed concerns over the funeral director allowing the brother to view remains.
One person didn't have any more right to say than the other.
Right. Sure.
Do we know that that either one of them didn't have a durable power of attorney or anything that extended beyond?
We weren't provided any of that information.
If they were, you would have probably gotten that. Somebody would have owned up to it, I'm sure.
Correct.
Okay.
I guess I'm just not so sure if I agree with the unprofessional conduct. That's a to someone, I would think. I mean, I'm fine with a letter of warning, but I don't believe that deserves a fine.
I agree. I've had that happen to me before between two sisters. I put you in the back.
Did the recommendation come from the past history of the firm? Is that one reason?
Yes.
But
This specific
specifically, well, you said, well, what's the unprofessional conduct? I'm a little confused too.
The unprofessional conduct was the funeral director telling the complainant to pray about it. She made a point in her complaint to express that she was not happy with that comment that he made to her. Respondent admitted that he told her to go pray about it when she expressed concerns over the funeral director allowing the brother to view the remains.
It probably boils down to, I don't know, but I'm just thinking she probably felt a little slighted when he told her just, you just go pray about it. But, that wasn't necessarily the thing. It was that he let somebody else view when she said not to. But, because one person didn't have any more authority than the other, really.
Correct, as far
Yeah.
as we can tell, yes.
Yeah. So it's one of them things. You put the undertaker right in the middle of a family dispute. Because which side do you take? I mean, do you take the one that do you take the one that wanted to view or the one that didn't? It puts the undertaker in a bad position.
Definitely. I make a motion to close.
Okay. Did y'all want to add a letter of warning or anything?
I don't. I think just close it. Do you?
Oh, a motion by Mr. Cochran, a second by Mr. Bridges to close. All in favor? Opposed? Next.
The next items are item 9 and item 10. They are related. Complaint 2018-01131 against the establishment with some disciplinary history, and complaint 2018-01131 against the funeral director with no disciplinary history. The complainant made numerous complaints against the respondent establishment and respondent funeral director. Our investigation, however, revealed these complaints were not credible, and as such, it is our recommendation to close this complaint. Listed below are the complainant's specific allegations and the respondent's responses to the same. 1. Complainant claims she was the daughter of decedent. Despite this, the respondent funeral director catered to the wishes of her cousin/decedent's nephew and his mother/decedent's sister. Complainant purports respondent funeral director deferred to and consulted with them on procedures instead of her. A. Respondents assert complainant agreed to allow the above individuals to arrange the ceremony prior to her arrival, and that complainant approved, validated, sanctioned, and confirmed those arrangements. 2. Complainant alleges respondent charged an acceptance and funding fee of $443. A. Respondent indicates complainant elected to use a life insurance policy to pay for the services. The respondent assigns all life insurance policies to a third-party processing and funding company. That company verifies coverage with the insurance company, then advances the amount of the arrangements to the respondent. The fee was for this service. 3. Complainant purports she told respondents she believed decedent's burial arrangements were taken care of before his death, but respondents denied arrangements or details of service and denied payment for the services having been made. A. Respondents explained while decedent met with the funeral director before he passed, the decedent did not make any payments or arrangements at that time. Rather, he advised his nephew, complainant's cousin, would handle his final arrangements. 4. Limousine service was late to transport the family to funeral services, and the list of persons to ride in the limousine did not include 2 people originally designated to ride in the limousine. A. Respondents indicate they arrived at the residence in a timely manner and that the limousine driver simply called the list of names provided to him by the family, which the complainant did not object to. 5. Respondent funeral director drove the lead car in an erratic manner. A. Respondent funeral director indicates that when driving the escort van, one must pace the light so as to avoid breaking the procession, which requires one to speed ahead, to catch the traffic light, or to block an intersection. 6. Complainant claims she requested a DNA sample on several occasions, but respondents advised 1. She was the second person to make a request, and 2. That they would need to speak with an attorney before allowing her to collect a sample. A. Respondents indicate that at the time complainant requested a sample, she was informed that since there was a question with regards to the decedent being her father, they could not give a specific time or date when someone could retrieve a sample, because they would need to discuss the matter with counsel and the family. After speaking with counsel, respondents informed the complainant a DNA sample could be taken. Complainant admitted her lab technician was able to collect a DNA sample before the decedent was buried. B. Respondents indicate they had no knowledge then or now of anyone other than the complainant requesting a DNA sample. 7. Complainant alleges respondent funeral director made the comment that, quote, men don't always tell the truth to everyone about who their children are, close quote. A, respondent funeral director denies making this statement. 8. Complainant claims the cosmetic preparation of the body was not satisfactory. Decedent's fingernails were uncut and extremely discolored. Family members witnessed respondent trimming decedent's fingernails in their presence. A. Respondent funeral director indicates he has known the family for more than 36 years and prepared the decedent in a manner that the decedent normally appeared, with long nails. B. Respondents also indicate when the decedent was casketed, his hands were in a position that they did not show. A family member raised the overlay, noticed the length of the decedent's nails, and asked for the nails to be trimmed. Respondent funeral director indicates he normally would have waited to trim the nails after the viewing, but to appease the family, he obliged the request at that time. 9. Complainant purports there was no discussion about or approval of a public viewing. A. Respondents indicate the viewing and other arrangements were discussed with the complainant. Respondents indicate an opportunity was extended to complainant to make any changes, but she declined to make any changes and assured him that she was pleased with the arrangements the family selected. 10. Flyers were created and distributed at a local restaurant with the announcement of decedent's viewing and services. Respondents indicate the information referenced as a flyer was simply a copy of the information that was published in the newspaper. It was provided at the request of the owner of a restaurant that the decedent visited daily. 11. Respondents allowed complainant's cousin to interrupt the service to announce an omission from the program. A. Respondents indicate they did not tell complainant's cousin to make an announcement. Respondents cannot control complainant's cousin's actions. 12. Complainant told respondents after the funeral service that she did not want respondents to perform the burial. She reports the respondent funeral director told her this was fine, but that she would need to sign paperwork and pay for the funeral services in the event the insurance claim was denied, as well as potential additional charges for storing/holding the body. Because she was unable to provide respondent with a personal check, she left decedent's remains with respondents for the burial the next day. A. Respondents indicate they did not request a personal check from complainant during their meeting. The respondents indicate they had already been paid by FAC and that the only services left to render were to transport the remains and the family to the cemetery for the burial. B. In response to the storage fee allegations, respondents indicate there would be no need for a storage fee. 13. The other funeral home complainant called the respondent funeral director and told him they would pick up the remains, but respondent purportedly rejected this, telling them that complainant would need to complete paperwork first. A. Respondents indicate while they did receive a call from another funeral home inquiring about the remains, it was explained to the funeral home that the issue had been resolved. 14. The limousine service was 30 minutes late on the day of the burial. Complainant purports the respondent funeral director drove the hearse in an erratic manner. A. Respondents indicate they arrived at the family residence and then cemetery in a safe and timely manner. Respondents indicate the funeral director did not drive the hearse. He drove the escort vehicle. 15. Respondent funeral director was the notary on a quitclaim deed transferring decedent's property to his sister, executed 2 days prior to his death. A. Respondent funeral director indicates that on July 20, 2016, he was asked to notarize a paper for the decedent at a healthcare facility. He also indicates that he later attended the probate hearing involving the deed at which the judge ruled in favor of the sister and upheld the transfer without reservation or scrutiny. 16. The healthcare facility notified complainant that, quote, those people, close quote, had been there, quote, trying to get decedent to sign something, close quote. Complainant purports the healthcare facility also advised staff intervention social workers had asked them to leave. A. Respondent funeral director indicates that while he was present at the facility, no one requested him or anyone else leave the premises. 17. Complainant was purportedly told by a bank staff member that respondent funeral director called and inquired about the details of the power of attorney she had presented relative to the decedent's bank account. A. Respondent funeral director indicates he did not call the bank to inquire about the decedent or his business affairs, but on one occasion before the funeral, while at the bank, he was questioned by a teller who asked if he was handling the services for the decedent. He indicates the extent of the conversation was telling the teller the date, time, and location of the service. 18. Complainant did not receive a copy of the death certificate dated August 10, 2016 until August 19, 2016. The additional copy she requested from the Health Department on August 16, 2016 arrived on the same day as the one sent by respondent. A. Respondent funeral director indicates he sent one copy of the death certificate to complainant through FedEx overnight delivery. He also indicates his assistant forgot to mail the additional copies via regular mail, but upon discovering this, he immediately mailed the additional copies to the complainant. Recommendation, close.
Motion to accept.
Second.
I have a motion by Mr. Bridges, a second by Mr. Cochran to approve. All in favor?
Aye.
Opposed? Thank you, Ms. Gino. Next item is our director's report. Mr. Gribble.
Thank you, Mr. President. First, the legislative update. We have a list of the bills that are either directly or indirectly affect the Board of Funeral Directors and Embalmers. The first one listed is Senate Bill 1517, House Bill 1611. As enacted, it extends the Board of Funeral Directors and Embalmers for 6 years to June 30th, 2024. Next, we have Senate Bill 2046, House Bill 1979. As introduced, extends the registration period for apprentice funeral directors, apprentice embalmers, and mortuary school students from 2 to 3 years, or until the registrant has completed the apprenticeship requirements, whichever occurs first. This passed the Senate on March 15th, passed the House on February the 26th, and was sent to the Governor on April the 2nd. And Ms. Hooper has a...
And that one has been signed into law as of April 9th.
Senate Bill 2458, House Bill 2537, regarding professions and occupations. As introduced, establishes apprenticeship programs for professions regulated by entities administratively attached to the Division of Professional Regulatory Boards. Passed the Senate with Amendment Number 3, which is 016361. This is on your iPad, this amendment is, and that passed the Senate on April the 5th, and on March the 27th it was sent to the House Calendar and Rules. Senate Bill 1876 and House Bill 2305, as introduced, exempts sales of caskets from sales and use tax. Senate Bill 1948 and House Bill 1891, as introduced, authorizes a trustee to establish a single trust for all pre-need funeral contracts issued by multiple pre-need sellers instead of having to establish a trust fund for each pre-need seller. Senate Bill 2091, House Bill 1889, as introduced, lessens the amount of time that a seller of a pre-need funeral contract has to retain records concerning the pre-need funeral contract and information relating to the sale from 5 years after the death of the beneficiary to 3 years. Senate Bill 1973 and House Bill 2179, as enacted, provides that a contract between a purchaser of a pre-need funeral contract and a travel protection service provider is not a contract of insurance. This is Public Chapter 623. And the website's listed there for you to do your any type bill search that you would like to find the exact status, as that changes now almost, or could change from day to day as the legislature is. Next on the agenda is the licensee report. This is a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of March 13, 2018 through April 9, 2018. Out there before you, 2 establishments that have changed ownership and some individuals that have issued either a funeral director and embalmer or one of the other license. Also, closed establishment report. We have no establishments to report closed to you since the last board meeting. Disciplinary action report. This is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to Board authority. and as reported on the February 2018 Regulatory Board's Disciplinary Action Report. Listed there, the violations and the civil penalties. Complaint report, as of yesterday, in the funeral director and embalmer profession, we had 32 complaints. Establishments, we had 41 complaints, for a total of 73 complaints that are open at the present time. President, that concludes my report. I'll be glad to answer any questions that any board member has.
Questions from the board for Mr. Gribble?
Move to accept the director's report.
Second.
A motion by Mr. McKinney, a second by Mr. Duffer to accept the report. All in favor?
Aye.
Opposed? Thank you, Mr. Gribble. Next item on the agenda is Rest Haven Memorial Gardens, funeral establishment in Dandridge, Tennessee.
Mr. President, I've been advised to recuse myself. The manager is a former terminated employee.
Let the record show that Mr. Bridges has recused himself for this particular matter.
President, the board office received a letter on March the 9th from Mr. Bruce Claiborne. Said, as per email on March 15, 2017, from the Tennessee Board of Funeral Directors and Embalmers, signed by Mr. Robert Gribble, I am respectfully requesting for permission to appear before the board at the scheduled funeral board meeting on April 10, 2018, this being more than 365 days after the issuance of my establishment, license number 1534, for Rest Haven Memorial Gardens in Dandridge, Tennessee. My hope is to request permission to perform additional services pursuant to Tennessee Code Annotated 62 it says 51-101. It should be 62-15101. It's very truly Bruce Claiborne, Rest Haven Memorial Gardens. And you have a packet of information there that is before you. Four representatives from the establishment. And also in that packet is a letter dated yesterday that further describes to you what Mr. Claiborne's wish and desire is by being here today. Gentlemen, if you will, each one of you please introduce yourselves for the record and let the board members know you purpose.
Gentlemen, if you would speak into the mic, as it can be recorded.
Right. I'm Bruce Claiborne. This is Shannon Parks, our funeral director. Next one's my 18-year-old grandson, the first one, and he graduates this year. He's skipping school today, if that's...
Speak into the mic, please, sir.
Here, let me get it over here. Is that... Okay, let me back up. My grandson, the 18-year-old sitting next to Shannon, is 18. He's here today because I wanted to introduce him as our future because he's going to funeral director school as soon as he gets out of high school here. Like I said, he's skipping today. And then my son, Slade Claiborne, is on the end down here.
Members of the board, do you all have questions in regards to this request?
I will provide the board with a little bit of background. You all have the agreed order of license probation in front of you. This order was entered March 14, 2017, after Mr. Claiborne appeared at a meeting and the board. Pursuant to this agreed order, the licensee was subject to a probationary period of 2 full calendar years and only permitted to perform direct cremations and engage in the sale of pre-need funeral contracts during the probationary period. The order further indicated that after 365 days, the licensee could request to appear before the board for permission to perform a wider scope of services. And so that is what Mr. Claiborne is requesting from the board today. You all do have a number of things in front of you. One of the documents would be the establishment inspection report. You also have several letters from individuals that support the expansion of services, and you can review those, as well as a copy of a signed document. It appears to be signed by approximately 50 individuals within that community that support the scope of authority that Mr. Claiborne is here proposing today. Part of the reason, well, the primary reason that this agreed order was entered was due to issues that the establishment had and the consent orders that were put in place to deal with those issues. And one of the things that we've done in reviewing this request is gone ahead and requested an additional audit in association with this request. So we would ask that you all consider and hear from Mr. Claiborne, and understanding that the board office is in the process of scheduling an audit just to make sure that the establishment has in fact been in compliance prior to additional authorities being granted. It's certainly within your discretion to grant Mr. Claiborne's establishment the full authority to operate today. We have gone ahead and scheduled that audit in the event that you all wish to have those before a final decision is made on the full authority being granted.
When's that been scheduled?
The 17th, and let me add to that, on last Friday, my daughter sent, there's only 5 contracts for him to examine. So I sent everything over to him that he needed, that he would ask us for when he came in. He's already looked over them. He said everything looks good, but my boss, Bill whomever, told me that I need to go ahead and do the exam and go ahead and do 2018 from the beginning of 2018 to date. And I will say, like I said, there's not that many of them. They're all perfect and right. We've looked over them ourselves and we understand. And I can guarantee you that that audit will have no problems whatsoever. As I said, he's already looked at the 5 and all the information that we sent in and the reports at the end of the year. Yes, and we do have them with us. I called Jeremy this morning and had asked him about it, and I said, can you give me a report? He said, well, they told me they wanted me to come on the 17th and go ahead and do 2018 to date. I said, that'll be fine. I will see you then, Jeremy.
Board members, this is the pre-need funeral funds audit. This is what being discussed now is the audit for pre-need funeral contracts.
It does not pertain to the cemetery.
No, sir. The audit that's been requested to do at this time does not pertain to the cemetery.
Mr. Claiborne, our paperwork says you want to expand your operation. Would you kind of explain to us what your plans are and what you want to do?
Yes, sir. In simplicity, I want the same exact license that each of y'all have and every other cemetery or funeral home in the state of Tennessee has. It was stated here before, I think by President Helms when I was here on Valentine's Day last year, the 14th, that I had the only establishment in Tennessee for cremation only. That's what we had requested, and we had intended when we came to get a full establishment, and not piecemeal, but to be able to do, as I said, everything every other funeral director can do. In my letter it states, and I'll say, I'm 70 years old. I was March 2nd. I've been in the cemetery business 51 years this year. As far as cemetery, I can say I probably have more experience than anybody sitting in this room. And we, as the letters that were sent, I could have brought you 150 letters or more if I needed to, and I could have brought a lot more signatures, but we just started doing that 2 or 3 weeks ago, and we had property owners that came in and they said, sure, we'll sign your letter, and yes, we'll use your funeral home. I have a lot of people in my community that respect us, that's done business with us, and they want us to have a funeral home and offer them services. Some of them are unhappy with other funeral homes, which I won't name. But I will say that even as I came here today, if you'll look at the letter, that Mr. Buddy Mays, who was kind enough and caring enough to me to give me use of any of his funeral homes. He has their Mays Mortuary, but he also owns a Brown Funeral Home, which is located within 5 to 5.5 miles of me in my office in Newport. I'm in the edge of Dandridge, right next to the Cott County line. He's offered to help me too, which I appreciate because he didn't have to. 2 other funeral homes around me turned me down. I also have another letter that it wasn't even necessary to do for the funeral home from last year. Don Allen said he would also let me use his, but Mays is closer, and that's the reason why I presented that letter. I'll also state that as far as we were talking about this before, it's very important that everyone here know. Since I left this meeting, and I called and talked to Mr. Gribble on the 5th, and I told him, I said, you said something that day. He was sitting over here close to where Mr. McKinney is, and he said that he had talked to the commissioner that week, and this was about being late on deposits. I said, I'd always been, didn't think a lot about it. He said, she's serious about paying it on time. And I made up my mind then. And since that date, I have never been late on one deposit. I think my daughter pointed out in this letter there was 26 of them. They've all been timely. They will continue to be, and if I'm ever late again on any deposit, whether anything in the cemetery, it will only be by accident, something that was overlooked, because we're very, very cautiously watching this. And as a matter of fact, I irritate my daughter at the end of the month. We'll get near the end of the month, and I say, have you got my merchandise trust and improvement care ready yet? Daddy, it will be ready. And then the next day I'm telling her again, so once the month, she said, let the month in. Once it's done, they have been and will be paid. And that's the only reason that we had a debate before. Mr. McKinney, I think, at least 3 times brought it up, but he brought up the fact, talking about the fact my son sold insurance, funeral policies through insurance companies, which irritated my son, and I asked him to calm down because I knew where you were coming from, but I never realized the importance to that day, and that has been corrected. So I'm here humbly requesting that we get our full establishment license, as I said, that each of y'all have. I deserve to be able to make the money, and I will say this, we have turned down, I think now my son told me there's 60 some odd funerals of people that he sold that wanted to use our establishment that couldn't, that we had to send them to other funeral homes and give them those profits. And we're talking about probably $150,000, $200,000 worth of money that could have gone into our coffer instead of theirs, and but because I don't have an establishment. And that in itself is unfair. So if there's anything that I need to do so that my family can have an establishment and we can start making money, and my grandson, after he gets out of school, can work for me instead of somebody else, I would deeply appreciate it.
Are you planning on building a facility or a place to have services or visitations there at the cemetery?
What I'm doing, I've got the money sitting in the bank now, and I've already got the plans for an embalming room with a large walk-in cooler. There's no other walk-in coolers in my area, any funeral home that has it. Ours will be the largest around. And my son-in-law and my daughter are both funeral directors. They also have the crematory in Mohawk, Tennessee, and they do my cremations for me. They have a walk-in cooler, but I don't want to have to take someone up there. We're going to have our own. Are we going to build a large funeral home? Absolutely not. I think that'd be one of the most foolish things that any funeral director could do in this current age of cremation, and I believe everybody sitting here understands it. But we do have a cemetery, and we are going to have an establishment, and we will probably build an outside pavilion that we can have open-air funerals like I had with my mother-in-law that we were very happy about in Chattanooga, and people liked it because it was different. But as far as a big funeral facility, absolutely not. But I have everything I need to be able to pick up a body, store the body, or will have soon. Now, right now I do through May's Funeral Home, but after we build our building, We've got everything we need, and some of we got's better than anybody else has around us.
What is, let's see, I'm looking here. And you're going to operate under the name of what?
Right now, we're operating under the name of Rest Haven Memorial Gardens, the same as our cemetery. We may change that name later on. I don't know. I haven't. My first goal is to get my establishment license, and then we can make changes as we go, just like the rest of everybody else does, sir.
Claiborne, if I understand your request correctly, in addition to asking for an unrestricted establishment license, you're also asking that your probation period be terminated.
Yes, sir, if the board's willing to do that, but if they're not, I'm okay with it because I'm not going to break any rules. And I was listening here today to the complaints, and it made me think, should I be asking for this license? And I know you all face that, and a lot of times we have people that are unreal. But anyway, we've never had, as I stated before when I was here, we were behind on our, and the reasons why that we had gotten behind over the years, I never thought it because I always had the money backed up to put in there, but I won't go back into that. Let me just say, we have never, one time, no customer of mine has ever had to wait one day to get anything ordered that money was in merchandise trust. If they own it, when the day they die, if we've got a complete description of the marker has been designed, we order it then. We don't wait. And when it comes in, it does not sit in our cemetery like many. It gets put down unless it's rain. If the weather's too bad, then no, we won't go out there and try to put it in. All of my maintenance people know the day the weather's good, it goes down, they get what it is, and I don't care what it is. That's how we operate. And any family that's ever dealt with us will tell you that, just like the signatures and the letters that we have.
I will say that the agreed order provided for Mr. Claiborne to return after 365 days and request additional authority, but it was drafted such that the probationary period would be for the 2 full years, and after that it would expire and the license would be unrestricted. One of the things I do think it's important to address is that the board did have a substantial basis for the actions that it took last year regards to proceeding in this manner with this particular establishment. We presented evidence to you all, we being legal, consent orders and such, regarding actions that were taken by the licensee that were not in compliance with their rules and laws. And that was the basis by which the board reached its decision to issue this license for the 2-year probationary period. If the board is inclined to grant Mr. Claiborne's establishment with the authority to perform the full scope of services that can be performed under the license, the board does have the option to authorize the board office to issue the license pending no examination findings, meaning if the audit results are clear, you all could do a motion today that would give the board office the authority to go ahead and issue the license rather than Mr. Claiborne having to come back and reappear at the next meeting. So that's one option for you all to proceed. Now, Mr. Claiborne would still be on probation for an additional, it's less than 365 days now, but it would be a total of 730 days from March 14th, 2017 when this was executed.
May I respond again? Yes, okay. I agree with what she just said. I don't have a problem with the probation. And just listening here today, as I said, the type of complaints you can get, and I'm surely not going to ask anybody to pray for me today or pray about it, even though before I left home, I have a lot of Christian friends that are praying for me.
President, I have some thoughts that I would like to share for the record that I hope would be pertinent to our discussions today. I'll begin by stating that I was not a member of this board when Mr. Claiborne first submitted his application for an establishment license in February of 2017. I have watched the video of that meeting, and I have reviewed the agreement that was entered into between Mr. Claiborne and this board, and I would like to touch on the probation period that is discussed in the agreement. I believe the description that best fits a probation period for our purpose would be an agreed upon and fixed period of time during which an individual or an entity is subjected to various tests and trials, if you will, to ascertain fitness for a particular purpose. The length of time in this case was 2 years, and the fitness of purpose is involving the lawful provision of goods and services related to the death care industry and regulated by this board. The tests and trials that I refer to are designed to be administered impartially through the statutes, the regulations, and the rules that govern the provision of goods and services related to the death care industry and governed by the laws of the state of Tennessee. As a board, we have objective tools that we can use to measure that performance. Those tools would include annual site inspections of the establishment in question, an annual examination of the records of the establishment as pertaining to pre-need trusts in particular, and the establishment's history with the department. It's my understanding that a site inspection has already been performed, and I believe that's a part of our packet here today. The history is easy to determine by reviewing the records of the department, and as Ms. Hooper has already referred to, the examination of the pre-need funeral trusts is still pending. In order for us to move forward, it would be my suggestion that it would be prudent for us to grant this request, if the board so chooses, based upon the condition that Ms. Hooper stated, that being a successful completion of the pre-need examination. And I would suggest that the probation period continue as laid out in the original agreement, especially so if we choose to grant an expansion of services being provided, so that this board would have an opportunity to monitor those services as they begin to be provided for a period of almost a year prior to that probation period expiring, because of the specific abilities that the agreement gives to this board in the event of a violation that occurs during that probation period.
That all in a form of a motion?
That's what I was, yeah.
I will make a motion to approve the request for a full establishment license contingent upon the successful completion of an examination of their pre-need trust funds, the understanding that the probation period would continue per the terms of the original agreement signed in March of 2017.
Second.
Yeah.
I have a motion by Mr. Shackford, a second by Mr. Duffer. Is there any additional discussion?
Do we need to set a specific date, or just let the office issue that license as soon as the audit is complete?
I would suggest letting the board office listed as soon as it's complete so that Mr. Claiborne's establishment could go ahead and start accepting those customers.
Any other discussion? All in favor? Opposed? Congratulations, gentlemen.
Thank you, sir. And may I add, I'm being told to shut up. I need to add one little thing, and that is, and I won't go into it, but back, I've looked, when I was here before and Mrs. Hooper brought out the reports of my exams, I looked at it and I was blindsided because I didn't have my response to those. Now, I just will say this, if anyone could read all of my responses as to what happened, it wasn't near as bad as what it looked. For example, I'm looking at it here where it said I owed $35,534.92. I did not owe that. I did not have to catch it up. Those were loan crypts that were in the ground that when Jeremy, who is a very good auditor, by the way, he's one of the best we ever had, and my daughter and I love him to death, even though we hate to see him coming because we don't know what he's going to do, but he's always been very nice, and he's actually covers things better for our customers. Actually, ultimately, it's kind of like when you get pulled over and you're speeding and you think you're kind of mad, you wish you didn't do it, but yet the officer gives you a ticket to protect you from killing yourself and somebody else. So we can't really get mad at him, get mad at ourselves. So that's the deal. But Jeremy does an excellent job, but he found some things that weren't really there, and I proved that it wasn't as it was. But the lawn crypts, they were all in the ground. But he didn't ask me. He assumed they weren't, and so therefore they were asking me to set up, before the law was changed, a funeral home, whatever it was, trust fund, and fund 100% of what I sold them for. I said, well, I can't. They're already in the ground. So I just wanted to make that response. I was over and over the years behind, but never behind on, and this is on my funding. When I had an exam, it was all caught up. Never was it. And no one was ever delayed in any merchandise for us to offer. And that's what it's in there for. I work, and our family works for our families and customers who do business with us. And I want to add that today because there won't be any problems in the future unless something is done accidentally or some complainant comes in that's unreasonable to deal with. There's nothing any of us can do about that, as we all know. But thank you all very, very much for hearing this and granting us that license. I would deeply appreciate it.
Thank you, Mr. Claiborne.
I will just say, on behalf of, the board office and the department, Mr. Claiborne, stated that he was blindsided, caught off guard by these things, and things were made to appear worse than what they were. We stand by what was presented at that meeting on that day last year, February 2017. And, even with this audit finding that the cemetery examination that I'm looking at from 2016, we have records that it was, in fact, mailed to his establishment. So to the extent that anything is being suggested to have been done wrong internally here, we want to say on the record that we stand by what we presented to you all as true and accurate. And of course, with this particular examination that you all made this full license contingent upon, if there are any findings and Mr. Claiborne has issues with those findings, we would proceed as usual and communicate with him regarding those findings to address any potential issues. But we don't anticipate any issues based on what he sent us so far and the volume of contracts that they've done over the past year.
Thank you, Ms. Hooper.
Thank you.
Next item on the agenda is the approval of license applications.
President, there are no individuals nor establishments to come before the board today.
Is there any new business that come before us? If not, I'll entertain a motion to adjourn.
Motion to adjourn.
Second.